Hi, my name is Bhargavi, and I'm here to speak about a problem that is widely experienced but not spoken about much in the context of accessing justice in India. This is the problem of information asymmetry between litigants and lawyers. I will begin by explaining the notion of information asymmetry, how it plays out in the context of accessing justice in India, and who can help us fix this. Information asymmetry happens when one of the parties to the contract has better or more information than the other party to the contract. Now, by itself, this is not problematic. We are all unequal in terms of knowledge, expertise, skills, and it's impossible to equalize it beyond a point. However, when the information asymmetry between parties to a transaction is significant, it can lead to many inefficiencies, leading to a complete market failure. The most commonly cited example of this is the market for second-hand cars. In a market for second-hand cars, the buyers believe themselves to have lesser or inferior information about the used cars that they want to buy. They end up offering a lower than fair market value of that car. This in turn drives out the sellers of the good quality cars out of the market. The buyers have no choice but to pick from the lemons. They make what is popularly known as an adverse selection. The second example of this is when a party who has better information ends up changing his behavior after the transaction is consummated. For example, when I buy insurance, I know much more about myself than the seller of an insurance policy. I may buy car insurance and then start driving more rashly because I have car insurance. This is the problem of moral hazard. In both these cases, the markets fail. How does this play out in the context of accessing justice in India? There is massive information asymmetry between litigants or consumers of the judiciary and lawyers or the intermediaries who facilitate access to the judiciary. This information asymmetry arises because of three problems. First, the search costs for lawyers in India are really high. This is because the Bar Council of India bans advertising by lawyers. Think of yourself as an employee in Rourkela who hasn't been paid his dues for over a year, and you're keen to take your employer to the insolvency courts. Your employer is a large steel company who is headquartered in Bombay. How do you, sitting in Rourkela, know who is the best lawyer for yourself who fits within your budget in Bombay? How do you know he's not already conflicted? How do you know whether he's offering you a good price? This is the search cost problem that is very much aggravated because of the lack of advertisement by lawyers. The second problem is price discovery. Price discovery in the legal services market is virtually non-existent. Pricing of lawyers is highly local, very case-specific, and often very client-specific too. How do you know whether what you are paying your lawyer is actually a fair price? The third problem is the problem of quality evaluation. Think of any service. Most services are amenable to quality evaluation. Think of a haircut. Think of medical services, which are rather complex. Or think of airline ticketing services. The consumer almost always is able to figure out whether the service has been delivered up to the expected standards. This is really hard for a litigant who wants to evaluate the performance of his lawyers. The monitoring costs are very high. How do you know whether a lawyer appeared on a scheduled date? How do you know whether he took an unnecessary adjournment? How do you know whether he had prepared for his case well? This is particularly problematic for people who are one-time litigants, who are already intimidated by the system. And it is very easy then to blame the slow judicial system for what are really, in effect, deficiencies in lawyering services. These are the three reasons why information asymmetry between litigants and lawyers is really high in India. Who can help us fix this, or who can help us mitigate it to the extent possible? There are actually three constituencies who have both the power and the responsibility to mitigate this information asymmetry. The first one is the Bar Council of India. In a world where information flows are seamless and information is the single most important empowering tool, there is no explanation for continuing the archaic ban on lawyer advertising. Hell, even Practo allows us to rate doctors today, a seemingly noble profession. By imposing high search costs, the Bar Council of India's ban on advertisement actually protects the better off, the more sophisticated repeat litigant, compared to a litigant who interacts with the system just once, but whose stakes are high enough to have actually interacted with what is a very complex system to an outsider. The second constituency that can really help in this regard are the courts themselves. A court, by displaying minimum service standards on its website, can put information in the hands of a litigant that can help the litigant hold his lawyers accountable. Imagine a court that displays the average time for disposal of cases that are filed before it on its website. Imagine a court that is able to display on its website how many cases on an average is it likely to hear. Imagine a court that displays the average number of dismissals of important relief applications such as bail applications. Putting this information in the hands of the litigant can significantly empower the litigant in asking questions of his lawyers and holding his lawyers accountable. In a world where even the sovereign displays minimum service standards such as time to processing a passport application, time to processing a visa application, time to delivery of welfare distribution in the bank account of a beneficiary, publication of bare minimum service standards is the least that courts can do. Finally, the private sector. In India, the innovations in the field of access to justice have fortunately or unfortunately come not from policymakers, but from the private sector. Be it digital case law search engines or online dispute resolution platforms, these services have made it significantly easier for litigants to access information compared to what are offered by the courts and the state themselves. In this context, the IT-oriented private sector has a massive opportunity to develop products and services that actually mitigate the information asymmetry between lawyers and litigants. Thank you.